Welcome to the Kennedy's Healthcare video series. This is the first in a series of videos and conversations with guest speakers which will address issues relevant to clinical negligence law. My guest today requires no introduction, and I'm delighted to welcome the fantastic Professor Dominic Regan. For those of you that don't know, Dominic qualified as a solicitor 30 years ago but has devoted his career to the implementation and development of the civil procedure rules. Dominic, your name is synonymous with the CPR, and if I understand correctly, Lord Justice Jackson described you as the authority for his sweeping reforms.
On all of his reforms, and at Kennedy's too, absolutely, thank you, yes. Yeah.
Today we will look at some key issues which affect legal practitioners, including Part 36, alternative dispute resolution, and cost budgeting. So, to dive straight in, Dominic, Part 36, it's a minefield.
Yeah, it is a minefield. And you've got this big sort of division between claimants and defendants, because Part 36 is brilliant for claimants. If they make an offer, the defendant fails to accept it, the claimant meets or beats their offer at trial, then that is going to cost the defendant a shed load more money, because the claimant is then looking at indemnity costs, not standard costs. The claimant is looking at the Jackson uplift, up to £75,000 extra free money, yeah? Enhanced interest on damages, enhanced interest on costs. So it's a real dilemma for a defendant, because if an offer is made, and claimants obviously should be making and do make offers because of the rewards I've just mentioned there, what then follows is that if the defendant calls it wrong, it's going to cost them, as I say, a shed load of money. So it's a really tricky issue for both sides, actually, to pitch the offer right and for the defendant to determine whether they should accept it or not.
Absolutely. It's a peculiar area of law, such that when I was a junior, it seemed a very straightforward area of law. Make an offer in writing, specify it has consequences of Part 36 and a relevant period. As you progress, you start to learn the unknown unknowns, and some of those can be particularly challenging. Something that crops up for us from time to time is the issue of the applicability of interest on an offer, and whether that plays into whether the offer's actually been beaten at trial.
So, well, what the rules say is that the offer is deemed to include interest up until the end of the relevant period. So that's what we're comparing, what the offer was at the time it was made, and ultimately what the court adjudicates, looking on the same principle. So that's an issue. There is a subplot here, if I can just talk about it, and that's the use of something called the Calon clause. So Calon was a court appeal case in 2019. And there's a lot of confusion about it, and I had the benefit of Miss Justice Pepperell, Sir Ed Pepperell, High Court judge, who incidentally, he writes the White Book notes on Part 36, so he's the top banana on Part 36. And so the point is this, from a claimant's perspective, they make an offer and it includes interest until the end of the relevant period. Now, of course, what we know from Part 36, and as you say, in the early days it all seemed clear until a case called Gibbon and Manchester City Council, which in 2010 we then brought in lots of new principles. But critically, an offer once made stays made and can be accepted weeks, months or years later, provided only the offer has not been expressly withdrawn, provided the trial has not begun. So the claimant's dilemma, and that's the angle where I'm coming from, is that they could make an offer today, right, we'll take $1 million, and then 18 months, 2 years down the line, a defendant quite rightly could pop up and say, we're accepting that offer, and because that would then mean the claimant would be losing out on interest if that offer were accepted in 2 years' time. So to try and mitigate that, in the Calon case, the offeror said, right, here's our offer, and from the end of the relevant period thereafter, if you accept this offer, you've got to pay us interest at 8% per annum thereafter. And so that is the Calon clause. So it is outside the Part 36 because it only kicks in once the relevant period has expired. And so the thinking is that if the offer is accepted at a much later date, the terms of the offer, including that provision about 8% thereafter, would mean the claimant would get interest. Now, what the court appeal actually said in Calon, which is in the small print, is, of course, if you're the defendant, a vital tactic here, and you're going to accept an offer 2 years on, you think, you know what, we better take it, I get that. Then, of course, what the defendant could do rather than accepting the offer and coughing up that extra 8%, what the defendant could do is make their own Part 36 back now to the claimant, not including the 8%, but making something perhaps a bit more generous, but not coughing up for the entire lot,
Sure.
and therefore putting the the ball now back into the claimant's court. So the claimant think, well, you know what, this is a good offer, we better accept it, and that's how one deals with it. So that's where the Calon clause comes in. Yeah. And in fact, can I just add? And it was in this well, not in this very building, but it was at Kennedy's event, and I was told a brilliant piece of wisdom that when Kennedys are first instructed in matters, they whiz through all the offers, all the correspondence, to see if there are any old, perhaps ancient, claimants' offers that have been made. And because if the claimant's made an offer and not withdrawn it, you can legitimately accept it, even though it was a long time ago, even though the value of the claim has rocketed in the interim. It's the offer has been made, it's not been withdrawn, the trial has not begun, you can accept the offer. And that's a major tactic that I learned from Kennedy's at an event probably a decade ago.
I think that's really interesting.
Yeah.
We often worry about the validity of an offer and
Yeah.
whether, I don't know if you're a proponent of using the court template Part 36
Yeah,
offer
yeah.
or the free drafted ones, which we often see.
Okay, so again, this is not me, I know nothing, God knows why I'm here, I'm an imposter. But Mr. Justice Pepperell in the White Book notes strongly recommends using the court form, primarily because it keeps you on the straight and narrow. It reminds you about things like the 21-day relevant period. And there are a lot of people, especially in this area, we're in the City of London, and they like to make offers in letters. And you know what? The danger, and there's authority on this, the danger is that you can say something in a letter, quite innocently, and it takes it outside Part 36. One example was where the offer said, if you accept this, you've got to pay us our costs up until the end of the relevant period. That's not what the rules say. It's costs up to the date exactly. You spot it straight away, but they didn't. There's a High Court authority, 2018. High Court said no, that's not valid because it's not compliant with the rules. If they'd used the form, bingo, they'd have been okay. So I'm a massive fan of using the form. Yeah.
That's good advice. I mean, sometimes the claim isn't capable of settlement by offer and acceptance. We do tend to move to alternative dispute resolution.
Yes.
That's what I'd like to talk to you about next. Now, the cynic in me thinks that it's sometimes used as a tactical manoeuvre. Do you believe I'm correct?
It could be. I mean, if you've got, if you're a claimant and you've got a ropey case, think, why on earth did I ever issue this, for example? You might be desperate. The last thing you want to do is go to trial because you'll be beaten black and blue and thrown out. However, the game has changed. Yeah. So in November 23, we had the Court of Appeal judgment in Churchill, which said that, you know what, judges do have the power to order ADR, and then that effectively was codified in October 24 when the rules were amended effectively to put that into the CPR. So you've got to take it really, really seriously these days, and it's not impossible to for a defendant to say we're not prepared to engage. If, for example, a claimant was making quite incredibly serious allegations of fraud, outright dishonesty, I can see why a defendant would say, we've got to clear our name. This is a travesty. But broadly, the view of the senior judiciary, and I don't go out round to the house for tea, but I have a fair few chats with, get to see them, and their view, and Sir Geoffrey Voss, the Master Rolls, who's the best Master Rolls we've had this century, he is bonkers keen on ADR.
Okay.
In fact, he said it's not ADR, it's not an alternative, it is part and parcel of DR. So I think a defendant has got to take it seriously. If ever a claimant suggests ADR, at the very least you've got to acknowledge their suggestion. Maybe you sort of postpone it and say, well, fine, we know your proposal. However, we haven't seen a medical report, we've not seen a schedule of loss at this juncture. It's premature, but it is really dangerous, as sometimes defendants did in the past, to say, never over our dead body will we ever do it. Yeah.
If a defendant were to do that, does that not bring us into an unreasonable rejection of it? And what are the potential consequences of that?
Well, exactly, because it goes to conduct, and in fact, the October 24 rule changes actually altered the cost rules to say that conduct towards ADR, unreasonable conduct in the context of ADR is relevant, or can be relevant to costs, and therefore can affect the liability of the party, of the defendant if they reject it. So it's incredibly risky, I would say, to say we won't ever do it.
And is the burden to prove that it was unreasonable, is that on the claimant, or sorry, is it on the party rejecting the offer of ADR?
No, the burden is on the party. Any party saying my opponent was unreasonable, they've got to show that's a great question. They've got to show the unreasonableness. It's not for you to justify your decision to reject. It's for them, and that's the point made recently by Mr. Justice Constable, which will be the authorities that are circulated after our talk. Yeah.
Okay, thank you, Dominic. That's really interesting. Moving it on slightly to something somewhat different, costs budgeting. Now, I would say that nobody really enjoys a precedent H or a precedent R, and I apologise to any cost lawyers who are listening. One of the things that does crop up in our practice on a daily basis really is whether there is a dangerous assumption by both parties that you can't budget for high value claims or claims involving a minor. What are your thoughts on that?
Okay, well, excellent. Well, again, the starting point is that the rules, Part 312 to Part 318 inclusive of the CPR, that there are exclusions, and indeed, if a claim is pleaded at over 10 million, excluded. If it's a child, excluded. But what is not widely appreciated is that the court can override that exclusion and drag these matters back. And again, there's an authority last year where the High Court did exactly that. It was a child claim pleaded over 10 million, liability admitted, and so it was excluded from budgeting, but the defendants took fright. The claimant was liability admitted. The claimants were, I think, doing all sorts of things, and the defence could see that expenditure was must be massive, and so they made application to the High Court for an order that it be put into budgeting. I know both silts involved. There's Alex Hutton for the claimant, very able Clinneg and cost counsel, and a lovely man called PJ Kirby for the defendant, and the master accepted that the spending looked to be rampant, and he said, the sooner I budget this, the better. And the relevance of that, so the answer is that if a case is budgeted, then Rule 318 says the court must have regard to the last agreed or approved budget when dealing with costs on the standard basis, and can't depart from that budget without good reason. So with all of that, it therefore followed that you're putting a marker down as to expenditure, and that effectively puts a lid on what the claimant can spend, and if they want to exceed that, then they've got the burden, and I think it's a heavy burden to show that it was right to go over budget.
Absolutely. Is it a perception of rampant spending that might cause a judge to say, no, this is a case for budgeting? Are there any red flags, triggers that defendants should look out for?
I suppose that the whole, you see, if the matter was proceeding in a sensible fashion and alarm bells aren't ringing, then I don't see why the court would even think about intervention. But so and because budget, I mean, the be all and end all was to control costs, and back in 2013 I interviewed Cyril, because I worked for him on budgeting from 2009 onward until he retired in 2018. And I said to him, because there were 109, I think, changes in the CPR under the Jackson reforms. And I said, Sir Rupert, of all your reforms, which is the most important? He said, without missing a beat, he said, cost management.
Wow.
And it's really a big thing now, and going outside our arena today. But we've seen in the vehicle emissions litigation last year, 150 million knocked off the claimant's spent by Mr. Justice Constable. So it is the concern is that it's no good at the end of a case, saying, oh God, look how much we've spent, because almost like the damage is done. And so the whole point of cost management is to put limits in place at the outset, early on, so people know what they can and really can't do.
One claim which I'm sure the budgeting and the costs incurred are absolutely humongous is CCC and Sheffield, which is in the Supreme Court. Are we any wiser as to when that judgment might be handed down?
Right, so CCC, the hearing, in fact, I attended the opening arguments in CCC, which was maybe about the 11th or 12th of February this year. So I'm expecting to see a judgment before the end of term. End of term is 19th of December 2025. Got the year right for a change. I have to tell you, my instinct, and that's all, and if I'm wrong, well, there you are yet again, but I think the claimants have lost. I really do. I thought the court, from the get-go, at the beginning of the appeal, and the court, when I said the court was hostile, I didn't mean they were nasty, but they were throwing in all these grenades, and you know what, I just really felt that it wasn't going to succeed. But we will have, I hope, a judgment by the end of this year.
I mean, the potential impact of that judgment going in the claimant's favour is massive for insurers and
it would add,
indemnifiers.
I think, about another £800,000 to one claim. So, and in fact, the judge who dealt with it in the first instance and granted permission for it to be leapfrogged to the Supreme Court without going to the Court of Appeal, Sir Andrew Ritchie, again, I know well because he was head of what was 9 Gough Square, and he's a very able judge, and so his judgment was very thorough, but the conflicting authority, and off to the Supreme Court it went. But the first thing the Supreme Court said, because the claimants were saying, oh well, the laws, the Court of Appeal got this wrong, and the first thing the Supreme Court said was, what if they got it right? You could just, yeah. So we'll see, but I really don't think the claimant's going to succeed. That's my take.
That's absolutely fascinating. Thank you. Thank you for joining us on this video conversation. We've obviously had a whistle-stop tour of Part 36, ADR, cost budgeting, and CCC in Sheffield. It would be remiss of me not to ask Dominic, knowing that it's a particular favourite of his, to ask for a wine recommendation now that the nights are drawing in. Do you have anything on your list for Christmas?
Yeah, well, I'm literally I'm writing the Council magazine Christmas wine column literally this week. So I was scouting shelves in Waitrose and Tesco yesterday. So there you are. But if you want a cosy red, Côte d'Or is absolutely reliable red. There you are.
Thank you, they're fantastic recommendations. Thank you very much everyone for joining us. Our next conversation will be looking at the development of AI in healthcare. If anybody would like any copies of the case law that's been discussed today with Dominic and I, please do get in touch.